Good afternoon. I will just say a few words in Arabic for the Arabic participants, and then we'll turn back to English, which is the language of the whole event. مساء الخير، شكرا للحضور. أود التنويه أن هذه الندوة ستكون باللغة الإنجليزية، وتتوفر ترجمة فورية إلى اللغة العربية بالإمكان الاستماع إليها من خلال النقر على أيقونة الكرة الأرضية التي تظهر في أسفل الشاشة. ويمكنكم أيضا طرح الأسئلة والاستفسارات عبر جزئية الأسئلة الموجودة على زوم. طبعا للمتابعين على يوتيوب ستكون الندوة باللغة الإنجليزية فقط، لكن سنعمل على توفيرها خلال الأيام القادمة بالترجمة إلى اللغة العربية. I will go back to English now. Good afternoon again. My name is Ammar Dweik. I am the Director General of the Independent Commission for Human Rights in Palestine. I would like to welcome all participants inside the Zoom webinar and others who are watching via live broadcasting. This event is organized by ICHR in collaboration with Law for Palestine. Today, we convene to address the grave issue of genocide during a period where Palestinians in Gaza Strip perish every minute. Those fortunate enough to survive the bombing are confronted with the threat of death due to starvation, disease, dehydration, or lack of access to medical care. The subject of genocide is not an academic debate. It is a critical matter of urgency that demands universal intervention to prevent its perpetuation. In pursuit of this objective, we are joined today by a panel of renowned experts in international law and the subject of genocide. All are endeavoring to respond to the following fundamental questions. How does the Genocide Convention and Rome Statute apply to the current situation in the Gaza and the broader Palestinian context? And to what extent can it be classified as a genocide? What are the state
Recording in progress.
What are the state responsibilities and individual criminal liabilities for committing genocide? What are the potential consequences for third states found complicit in this crime?
Recording stopped.
What obligation do third states and international community bear to prevent the ongoing genocide in Gaza? Is referring the case to the International Court of Justice a viable option? And last, what are we as individuals and organizations are supposed and required to do to stop this carnage? I will give the floor now to our panelists, starting with Professor Mu'taz Qafisha. Professor Qafisha is the chair of the Board of Trustees of Law for Palestine. He is Associate Professor of International Law and former Human Rights Officer at the Office of the United Nations High Commissioner for Human Rights in Geneva, and also Beirut and in Ramallah. He authored and edited 6 books and some 50 peer-reviewed articles published in international publishers and journals. Mr. Qafisha will address the issue of genocide classification and the current Gaza and Palestinian context. The floor is yours, Mr. Qafisha. You have 8 minutes, please.
Thank you, Dr. Ammar, and thank you for our colleagues or my colleagues from the Law for Palestine. I will divide, and I'm happy to be with this group of panelists in this session. I will divide my presentation into 3 parts. First is trying to answer the question why this case of genocide is unprecedented in the history of humanity. The second is the classification of the case of genocide in Gaza under both the Rome Statute and the Genocide Convention. And the third, what are the actions that can be taken and what has been taken until now. So let's start by the first part, is to answer the question why this case of genocide is unprecedented and unique at the international level. I think there are three reasons for that. Because first, because this case of genocide is taking place live. Everybody in the world is watching what is going on day and night. It's filmed and broadcasted all over the world. The second is the complicity of states, particularly the great powers, superpowers in the world, in this case of genocide. They are not only silent, but participating, adding and repeating this case of genocide. And it was very clear how, for example, Rishi Sunak came with a war aircraft full of bombs provided for bombardment of Gaza, and the same with Joe Biden, the American president. So they are not preventing or condemning this case of genocide, but supporting it and participating in it. The third reason is that even international organizations, and including human rights organizations, which are supposed to contribute to the prevention of human rights, international humanitarian law, war crimes, crimes against humanity, including genocide, are silent. And for example, if we give Mr. Karim Khan, the ICC prosecutor, he came to the region and he did not even mention the case of genocide and not even war crimes.
Recording in progress.
In Gaza, the same can be said regarding the High Commissioner for Human Rights, Mr. Volker Turk, who have not mentioned the issue of genocide. And even the UN Secretary General, he's putting both sides at the same level, as if the Palestinians are equal to the Israelis and not exercising their right to self-defense and the right of resistance under international law. So this renders all these bodies complicit, because they can't take action and they are not doing virtually anything in this regard. So this makes the case of genocide different from all other cases. If we talk about the Armenian genocide in early 20th century, the Rwanda genocide, the Bosnia, including Srebrenica genocide, Myanmar genocide, and the claims of genocide in Ukraine. So this is the first part. The second part is to I'm trying to connect the law with facts. And here I look at Article 6 of the Rome Statute of the International Criminal Court and Article 2 of the 1948 Genocide Convention. There are 5 components for the crime of genocide. 3 of them apply to the case of genocide that is unfolding in Gaza. First, according to both Article 6 and Article 2, let's say the first is the killing of members of a group, of course, intentional killing of particular national, racial, ethical, or religious group, which applies to the Gazans. And the killing is systematic. Until now, we have at least 16,000 persons killed, including 6,000 children, 5,000 women, 7,000 missing, and virtually killed in this conflict, only in time span of 2 months, which is more than all those killed in any other conflict in the world in comparable period, including all those killed in Ukraine over the past 2 years. The second component is causing serious bodily, and here I'm quoting, causing serious bodily or mental harm to the members of the group. And here, if we look at the facts, over 50,000 people injured. Trauma is all over Gaza, particularly for kids and elderly and women, destroying, as Dr. Ammar mentioned, destroying hospitals, schools, associations, municipalities. All facets of life are being destroyed in Gaza systematically and intentionally without having any military objective for that. The third component is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. And the facts are a complete blockade on Gaza, cutting off food, water, fuel, and medical supplies for Gaza, which creates lots of diseases and famine in Gaza. And this policy of committing these all the three components are publicly officially adopted by Israeli officials, publicly broadcasted, and everybody heard the statements of the Israeli Prime Minister, the Minister of Defense, and other Israeli officials. So this makes all elements of crime. If we look at the elements of crime in the document that was adopted by Assembly of State Parties of the ICC in 2002, we could see that all elements of crimes are met in this case of genocide. So what can be done, and what are the various actors are doing, particularly our organization, the Law of Palestine. I think there are two options that we need to explore, and I think other colleagues will explore these things. First is to approach the ICJ, the International Court of Justice, and I personally called upon the Palestinian Ministry of Foreign Affairs on October 8th to file a case of genocide, as Ukraine did after 2 months of the Russian attacks on Ukraine. And I think that would help in at least condemning that case of genocide at the international highest international court. That would put pressure even on the ICC if the ICJ says that this case is in fact and in law is a case of genocide. I think the court, the ICC, will be in a difficult position not to investigate this case of genocide. But the Ministry of Foreign Affairs, as far as I know, has not taken that step yet. But I think and probably there are certain reasons for that, because Palestine is not member of the UN and the ICJ. But other state parties, we have over 150 parties to the Genocide Convention, and I think any of these states can file that case, as Gambia did against Myanmar in 2019. Of course, to approach the ICC needs also another strategy. So what is the Law for Palestine is doing? And here I thank all my colleagues in the Law of Palestine. They are working on 4 fronts. First, institutional front, by corresponding and contacting various international actors working on the issue of genocide, sending over 40 letters to 40 states in the world, particularly European countries, Canada and other countries, creating a database for documenting and analyzing the issue of genocide, and collecting data in English, Arabic, and Hebrew in order to prove the intent for the genocide. Of course, to do some work at the academic and social level by conducting webinars like this one, and collecting experts, gathering experts from all over the world to work on this and creating a working group for that. And finally, to try to develop as much doctrinal work, bring certain precedents that can help in documenting and pushing towards filing lawsuits at the ICJ, ICC, and other international judicial bodies. That's it. Thank you.
Thank you, Dr. Kafisha. It is shameful and unfortunate that the most evident genocide crime that is, as you mentioned, broadcast to the world live, that we still have some important international actors do not recognize the situation in Gaza as genocide. I give the floor now to Professor Penny Green, who will address the topic examining genocidal elements, the current Gaza situation and historical cases. Professor Green is Professor of Law and Globalization at Queen Mary University of London. She has published extensively on state crime theory, state violence, genocide, mass forced evictions, and resistance to state violence. She is the founder and director of the award-winning International State Crime Initiative, ISCI. Professor Green, the floor is yours. Please, could you please unmute yourself?
Apologies. Many thanks, Amar, and many thanks to Law for Palestine, who've organized today's event. I'm really honored to be on a panel with such brilliant legal minds. I'm here not as a lawyer, but as a state crime scholar to offer a perspective which I hope adds a somewhat different framing of genocide, because it's clear to me that we need much more than the law to understand, expose, and ultimately challenge Israel's genocidal onslaught on Gaza. Israel's persistent violation of international law without consequence and the non-implementation of UN resolutions undermines the very credibility of the international legal order. With respect to Palestine, Israel has violated 28 UN Security Council resolutions, and it's done so with absolute impunity. This has meant that Israel has been able to develop into an apartheid state and commit genocide against the Palestinian people with no political or economic repercussions. In fact, Israel has been supported and enabled in its crimes against the Palestinians by Western global powers, most prominently the United States. We need to ask what this tells us about the international legal order and whether we should place any faith in it beyond its normative and symbolic power. My contention is that state crime, rather than a legal construct defined and punished by domestic and international laws and courts, is better understood as a violation of social norms, which may or may not reflect legal norms, and that following from this, organized civil society affords the most promising and effective means of challenging state violence. Legal definitions of crime are inadequate in understanding and identifying crimes committed by states, not least because states make, and the UN superstate, make laws and are notoriously unwilling to define their own practices as criminal. A Burmese activist I once interviewed described the rule of law under the Burmese military dictatorship as state crime. For Palestinians living under Israel's belligerent occupation, the rule of law is indeed very largely state crime. The definition which best captures state crime, I think, is human rights violations perpetrated by state agents in pursuit of state organizational goals. For the critical scholar of crimes of the powerful, the solutions to state crime lie well outside the frameworks of criminal justice, law, international conventions, and international courts. Instead, any such solutions are much more likely to be found in the struggles of the state's victims, or with those who advocate and organize as allies of those victims. And it's the organization of those victims and allies that not only has the power to challenge state violence, but is central in defining that violence as criminal in the first instance. Civil society has proven itself to be a much more effective force than international law in identifying, gathering and analyzing evidence, and naming and resisting the egregious crimes of states, particularly through campaigns of civil disobedience, mass strikes, boycott, divestment, and sanctions. Civil society enjoys widespread legitimacy as an authoritative check on the power and actions of the state. Because it operates from the ground up, it has far greater agility and capacity to recognize the processes involved in earlier stages of state crimes. Civil society has been at the heart and center of all evidence gathering in relation to Israel's crimes. And this work by civil society has led efforts to successfully name Israel's crimes as settler colonialism, apartheid, and now genocide. With respect to the charge of genocide, Israel's actions in Gaza and historic actions against the Palestinian people fit both legal and criminological definitions of the crime. Genocide requires both intention and action. Raphael Lemkin, the author of the term, wrote that genocide is not limited to acts of mass killing, but must include a coordinated plan aimed at the destruction of the essential foundations of the life of national groups. In Gaza, we have seen explicit evidence of Israel's plan and its continuing execution of that plan. Evidence of the plan can, for example, be found in Israel's 17-year-old...
Professor Green, could you please slow down for
I'm sorry.
the quotation? Thank you.
I'm sorry. Evidence of the plan can, for example, be found in Israel's 17-year-old Dahia doctrine, a doctrine premised on laying waste to a defined enemy area through overwhelming and disproportionate force, so as to weaken the population to the point where mere survival completely supersedes resistance. We see the doctrine enforced with Israel's announcement of a state of total siege of Gaza, cutting off water, food, fuel, electricity, and medical supplies, amounted to a clear statement of intent to commit genocide against the Palestinian people. The genocidal intention of the Israeli state is also embodied in the now very familiar nihilistic and dehumanizing statements by its leaders. In terms of the execution of this genocide, we have for the first time in history watched the carnage in real time. An estimated 20,000 people killed, the majority women and children. We've witnessed the carpet bombardment of the Gaza Strip with over 40,000 tons of explosives since October 7th, the destruction of over 100,000 homes. We've seen 1.7 million Gazans displaced, watched their trauma-laden marches to the dangerous south. We've witnessed hundreds of medics killed, at least 22 out of 36 hospitals destroyed, and the Gazan healthcare infrastructure collapse. 72 journalists have been killed, the most important Gazan university destroyed, and its president killed. Countless thousands injured and permanently disabled. A whole population traumatized beyond comprehension. We now have evidence of what former Israeli intelligence officer has called Israel's mass assassination factory, a dystopian artificial intelligence system called Habsara, which can generate targets at a faster rate than it attacks. And it's clear that civilians and their families are being directly targeted, and that the huge civilian death toll is in fact integral to Israel's genocidal aims. Thinking about genocide from a state crime perspective, we need to return to state organizational goals for which these crimes are being committed. In the case of Israel, the central goal is the establishment of a Jewish Zionist state in the territory that was once historic Palestine. This goal requires, as in the case of other settler colonial states, the annihilation of the indigenous population. Genocide from within this framing must be understood as a process which begins with dehumanization and ends with erasure. In between, and often concurrent, are a number of recognizable phases, occasions of litmus testing violence. So violence without consequence equals impunity and emboldens perpetrators to commit further violence. We have structural discrimination, most visibly in the form of apartheid. We have forced isolation, Gaza being the extreme ghetto and now slaughterhouse. And we have systematic weakening, which we are also witnessing now. The presentation and nature of these stages may differ slightly between genocides, but they are always present in some form. And what is critical is that understanding genocide in terms of its stages means that interventions can be made before the stage of annihilation. The Israeli crimes embodied in all these stages have been well documented by human rights groups, journalists, and scholars, but include routine settler and IO violence in the West Bank and East Jerusalem, house demolitions, village destruction of in the Negev, forced evictions, the detention without charge of thousands of Palestinians, including many children, the apartheid structures which make Palestinian daily life a misery, discriminatory laws, and the process of Judaization. Empirically and historically, we know that genocide unfolds over years and frequently decades. Israel's genocide of the Palestinians did not begin on October the 7th. For Palestinians, the genocide began in 1917 with the Balfour Declaration, when Britain simply gave their country to European Zionists looking for a Jewish homeland. What greater act of colonial dehumanization can there be but to dismiss the existence, history, and aspirations of a people in order to grant their land to others? Gaza is now in the annihilation phase of genocide, but annihilation is not the final stage. Genocide's final stage combines state denial with social reorganization. During this phase, the annihilated population is effectively erased from history, culture, and social life. Maps and textbooks no longer refer to the annihilated. Their traditions, their places, their contributions to society are gone. Palestine instead will have to be carried in the hearts and memories of its diaspora. But there is a chance, and this returns us to the centrality of civil society as the primary agent of resistance and change in a state crime analysis. Since October the 7th, we've seen global civil society out on the streets in its millions, crucially led by Palestinian resistance to occupation, denouncing Israel's genocidal siege and murderous bombardments. We've seen renewed energy for the boycott, divestments, and sanctions movement, and unprecedented pressure placed on elected representatives to demand a ceasefire and an end to occupation. If the final phases of genocide are to be averted, it is to civil society that we must turn. Thank you.
Thank you, Professor Green. I understand that you need to leave.
No, I can stay.
Okay, good. So we'll postpone questions to the end. Thank you for outlining this horrific stages of genocide. But I think our role collectively is to disrupt this process and to prevent it from perpetuation and continuation. I give the floor now to Dr. Hala Shuaibi. Dr. Hala is a board member of the Independent Commission for Human Rights and assistant professor of international law at Birzeit University, specializing in international criminal law. She earned her SJD from American University of Washington College of Law and has presented at various RIP conferences in the US and internationally on matters related to international crimes and accountability. Dr. Shuaibi will examine the historical and multidimensional aspects of the ongoing genocide in Gaza. Dr. Shuaibi, تفضل.
Thank you, Dr. Ammar. Good afternoon. In my contribution today, I'll be examining the historical and multidimensional aspects of genocide in Palestine.
Could you please slow down for the interpretation? Sorry.
Although it is imperative to focus on the moment in Gaza, it is also important to situate what is happening in Gaza today within the ongoing siege on Gaza for the past 17 years and within the larger Palestinian context since 1948. So what is genocide? I thank Dr. Mu'taz and Dr. Penny for clarifying what amounts to genocide. Whether, as mentioned in the Genocide Convention, and as Dr. Mu'taz shown, the elements are satisfied in Gaza, and as Dr. Penny informed us about the stages of genocide and where are we today within the Gaza context. So building on Dr. Penny's contribution, I want to start by asking the question, is there really any legal condition that genocide must be committed through high-intensity episodes of mass murder, or through conditions that are so dire that a population needs to suffer in a short period of time? Is there a time limit into which actions need to occur so that we call it genocide? The term genocide has historically been examined by most legal scholars as a specific set of acts or a specific incident, a historical event, if we may call it. But reality, as shown by Dr. Penny, is an ongoing system. It's a process that tries to reach its end goal, which is annihilation. But this does not mean that genocide only occurs when we reach that end goal. I think sociologists, historians, and state crime scholars have a deeper and truer understanding of genocide compared to us lawyers. We as legal scholars have been confined to terms that were created within the colonial system, making it harder for us to view the law from a liberation perspective, from how does it actually help people on the ground. Because in order to do so, to view law from that perspective, it means us, legal scholars, need to shed away our traditional understanding of the law. So with relation to Palestine, we have been hearing for the past 2 decades the term ongoing Nakba, which basically clarifies that the Nakba started in 1948 and did not end then, but continues until this day. It continues through a comprehensive military, political, economic, and cultural system with the intent to destroy the Palestinian people. The term ongoing Nakba assists us in understanding the experience of Palestinian dispossession and the history of Zionist settler colonialism. So as we consider today the term genocide, I think it's important to situate it within the ongoing Nakba in Palestine. Since 1948, there has been physical destruction of Palestinian villages, appropriation of land, property, and culture, as well continuous experiences of violence and dispossession in relation to Palestinians, wherever they reside. Today, as a result, millions of Palestinians are refugees, whether inside Palestine or in other places in the world. Given the time constraint, I will only look at a few examples to see how genocide has been happening since 1948 until this day. And this is what some scholars call slow motion genocide or incremental genocide. So in Gaza, Israel has imposed a siege for the past 16 years, deliberately inflicting conditions of life that are calculated to bring about the destruction of people in Gaza. So this is what scholars call incremental genocide or slow motion genocide. As complemented by Dr. Penny before me, genocide does not necessarily take the form of mass killing and murdering, but can be accomplished through depriving people of their basic needs and rights: denial of healthcare, denial of food and water, forced displacement. In Gaza, Israel resorted to economic restrictions, movement constraints, undernourishment, and an on-off bombing of civilians throughout the years. And finally, as we see today, accelerating its genocidal intent in its recent attack. On the other hand, in the West Bank, including East Jerusalem, Israeli authorities have been demolishing Palestinian communities while building illegal settlements. So these two practices should be viewed together consecutively. Why? Because these two acts attribute to inflicting on the group conditions of life where Palestinians view their life through threats of erasure. And erasure is an important aspect of genocide. Colonial history has shown us that genocide practices is based on building of colonies on erasure of native communities. For example, during the first quarter of this year, Israeli authorities demolished and more than 290 Palestinian old structures across the West Bank. As a result, 413 Palestinians were displaced only in the beginning of 2023. At the same time, we saw the highest number of demolition recorded in the West Bank in 2002 and 2003 since 2016. And the demolition of these structures and houses has been ongoing and has been increasing. At the same time, there has been an increase in settlements in the West Bank, East Jerusalem, and in the Golan Heights. 700,000 settlers have been illegally living in 279 Israeli settlements across the occupied Palestinian territory. So we have these two components which have been of Palestinian identity that have been showing us that genocide is actually happening on the ground on a day-to-day basis. And then we take a look at Palestinians with Israeli citizenship, who are considered third-class citizens at best. And they have been subjected to laws that brutally discriminate against them, with sections of the Israeli public viewing Palestinian minority as a demographic threat. So when considering Palestinian Israelis, we need to look at the socioeconomic differences between Jewish and Palestinian population groups. There is a huge difference, particularly with regard to land, urban planning, housing, economic development, and education. So this discrimination, coupled with practices to erase Palestinian culture and to silence their voices, can be viewed as part of the ongoing practices against Palestinians and the Israeli intent to destroy them. So the summary of Israel's efforts these past 75 years is nothing short of deliberate inflection upon Palestinians as a group to bring on life and death calculated death for the Palestinian people. So just to summarize, that international law has a long road ahead to actually comprehend and correctly characterize what is going on in certain countries in the world, including Palestine. Most intellectuals, media outlets, and politicians are so cautious with using the term of genocide. But however, we need to make sure that being cautious with the term does not undermine the protection of people. We have a moral and legal obligation to look into what's happening in Palestine through the lens of genocide, along with other crimes, of course. Otherwise, we risk allowing criminals to write history, wiping away their atrocities. I'm going to stop until here and then hopefully follow on if there are any other questions. Thank you.
Thank you, Dr. Hala, for contextualizing the ongoing genocide in Gaza in the broader Palestinian context of Nakba and the incremental genocide that has been taking place since 1948. As one of the participants here, Professor Dirar Alayan says, genocide committed in Gaza is not in vacuum. It is advanced step of genocide. We have to look at it as a series of crimes started from 1948 until now. I will now give the floor to Professor Quigley, since now after this analysis, people ask about legal consequences and what could be done. So Professor Quigley will answer the question related to state responsibility, criminal liabilities, and implications for complicit third states in genocide. Professor John Quigley is a legal scholar, professor of law at Moritz College of Law at Ohio State University, president of a club professor of law, and international lawyer with a long history of involvement in human rights litigation. His numerous publications include books and articles on human rights, the United Nations, war and peace, and the Arab-Israeli conflict. Professor Quigley, the floor is yours. Please kindly unmute yourself and please try to speak slowly for the interpretation.
Thank you, Dr. Amar. I am honored to be a participant in this panel. It is extremely important that the issue of genocide be understood properly, given that there is great resistance at the political level to characterizing what is happening as genocide. But if we look at the Genocide Convention as lawyers, I think it is quite obvious that genocide is being committed in Gaza, and there should not be a reluctance to apply the Genocide Convention to the situation. Dr. Penny spoke about genocide as a state crime. It has been ascertained by the International Court of Justice that genocide can be committed by a state. In other words, that the Genocide Convention applies not only to individuals, but also to a state. That is an issue that was not obvious when the Genocide Convention was adopted. But in 1996, in the Bosnia case, the court gave a judgment on jurisdiction in which it said that Article 9 of the convention, which talks about the responsibility of a state for genocide, that means that a state can be sued under the Genocide Convention. And then in the Myanmar case that Dr. Mutaz mentioned, the International Court of Justice indicated that suit could be filed by any state that is a party to the convention. To my mind, the most obvious way to allege genocide is to focus on the evacuation order that was issued on 12 and 13 October by Israel, which is not to say that genocide commenced only at that time. As has been suggested here, the genocide commenced much earlier. I tried to get a genocide case filed in the International Court of Justice 30 years ago against Israel, but that project did not succeed. In the present context, I think the most obvious way to frame a genocide charge is to focus on the evacuation order and to characterize it as Dr. Mutaz has indicated under Article 2, Paragraph 3, that speaks of inflicting conditions on a population that are calculated to bring about its physical destruction in whole or in part. And it seems to me that makes for what Professor Raz Siegel, a professor here in the United States, has characterized as a textbook case of genocide. That is, that ordering the population of the northern sector of Gaza to leave immediately under the conditions that existed was an infliction on the population of conditions calculated to bring about its destruction in whole or in part. Then one gets to the question of other states, and the Genocide Convention has an explicit provision on complicity. This is Article 3 of the Genocide Convention. So genocide is committed not only by the principal actor, but also by those who engage in what in the Genocide Convention is called complicity, or what in the English common law was called aiding and abetting. And that complicity consists in providing assistance to a state that is committing genocide and doing so with the knowledge that that assistance is being used in order to perpetrate genocide. So with genocide, you have the elements, as has been mentioned, of act and of mental state. And with regard to mental state, that means that the genocide is being committed by another state that provides assistance with knowledge that that assistance is being used to perpetrate genocide. And the mental element has been defined in the draft articles on state responsibility to mean precisely what I just said, namely acting with knowledge. It does not require that the other state desire the end of genocide. It suffices if the other state provides aid with knowledge that the aid is going to be used by the principal actor, in this case Israel, to perpetrate a genocide. And that is clear from the draft articles on state responsibility, the responsibility of states for an internationally wrongful act, the document that was composed by the International Law Commission in the year 2001 and was then approved by the General Assembly of the United Nations. Article 16 of the draft articles is on the topic of providing aid to another state that engages in an internationally wrongful act. And it specifies that liability exists if the other state acts with an awareness of the circumstances that constitute the internationally wrongful act. And it's quite clear here that other states that provide assistance are aware of those circumstances. They see what is going on in Gaza. They see that the evacuation order was such that it could be carried out only with physical destruction in whole or in part. The World Health Organization characterized the evacuation order as a death sentence for the population, a death sentence. So this is precisely what is prohibited by Article 2, Paragraph 3.
1 minute, please. 1 minute.
Please?
Please conclude in 1 minute, kindly. Kindly conclude in 1 minute.
Okay. Very good. I think that the fact that other states, in particular the United States, has attempted to caution Israel not to kill more people than it is killing is an indication that the United States is quite aware of exactly what is occurring. With that, I will cede the floor. Thank you, Dr. Amar.
Thank you, Professor Quigley, for this insightful legal analysis of the crime of genocide and also of the responsibilities of third state, criminal liability and responsibility of third state. We will now try to address the question that Dr. Kavisha mentioned in his presentation about referring the genocide to the ICJ as a preventive option. Is it a viable thing to do or not? To address this question, we have Ms. Juliana Benzotti. Professor Juliana Benzotti or Dr. Juliana Benzotti is Assistant Professor of Public International Law and International Criminal Law at Leiden University and co-authored of an amicus curiae submission to Palestine to the ICC. Submission on Palestine to the ICC. Benzotti has broad experience in law and practice of international courts and the tribunals. She worked with the International Court of Justice, International Criminal Tribunal for the former Yugoslavia, the Mechanism for International Criminal Tribunals, and the pre-trial judge and the appeals chambers of the Special Tribunal for Lebanon. Ms. Benzotti, the floor is yours.
Thank you very much, and thank you for having me today. Professor Quigley has already outlined the legal responsibility of Israel and its allies under the Genocide Convention, so I'll proceed from that. given the inaction of other organs and the political organs of the UN, many look to the International Court of Justice as an avenue to hold Israel and its allies accountable. And this is because the Genocide Convention in its Article 9 provides that disputes concerning the interpretation, application, and fulfillment of the convention can be referred to the ICJ. And yet, legal experts are divided on the opportunity of bringing a contentious case before the court concerning allegations of genocide. In my presentation, I will try to briefly explain the main arguments on both sides. First, I'll discuss who is entitled to bring a case before the ICJ and under what conditions. And then I will address whether this would be a viable preventive option. Let's assume that a dispute currently exists on the interpretation, application, or fulfillment of the Genocide Convention. A dispute is simply, in this context, a divergence of views as to whether certain acts allegedly committed by Israel and its allies amount to genocide, direct and public incitement to commit genocide, or even complicity in genocide. As a state party to the Genocide Convention, Palestine could bring a case against Israel before the ICJ, even if it's not a UN member state. It would only have to comply with certain requirements, but this is what it did already in another case concerning the legality of the relocation of the US embassy to Jerusalem. So it is technically possible. However, there will be some jurisdictional challenges that may militate against pursuing this course of action. When Palestine acceded to the Genocide Convention in 2014, Israel submitted a communication to the Secretary General declaring that since they do not consider Palestine a state, they don't consider themselves to be in a treaty relation with Palestine. And the problem with that is if the treaty is not considered to be in force between Israel and Palestine, also the jurisdictional clause, Article 9, would not apply. And then the ICJ would simply not have jurisdiction to hear the case. The US submitted a similar objection in the Jerusalem embassy case that is currently pending, but the court is yet to decide on it. So there is, in my view, an element of risk in pursuing this option. But as many others on this panel already said, the case could also be brought by any other state party to the Genocide Convention. The court's case law established that all states parties to the convention have a legal interest in ensuring that the convention is complied with and have standing to invoke the responsibility of another state party, even if they're not specifically affected by the internationally wrongful act. And this is the typical Gambia-Myanmar scenario. So concerning allegations of genocide against Israel, there would need to be a state that is willing to bring the case and that is not precluded from doing so by its own reservations. Some states indeed have a reservation to Article 9 that excludes the possibility of referring a dispute to the ICJ or attaches certain conditions to that. And under the law of treaties, reservations modify the application of the treaty between the reserving state and the other parties in a reciprocal way. So even if Israel does not have any reservations to the Genocide Convention or to Article 9, a reservation by the applicant state could bar ICJ jurisdiction. And that's why, for instance, it wouldn't be possible to bring a case against the US for breaches of the Genocide Convention because the US has a reservation to Article 9 requiring its consent. And the court has given a rather far-reaching interpretation of this provision in the Ukraine versus Russia case, where it concluded that the US is not bound at all by Article 9. Not that I think that is the best possible interpretation of that reservation, but what I think doesn't matter, but what matters is what the court thinks. Another condition for the court to have jurisdiction is that the respondent state was aware or could not have been unaware of the existence of a dispute. And so before establishing proceedings, it would be advisable to make sure that there are public exchanges between the parties concerning the genocide allegation. And typically this can be done through a diplomatic note, but in this case, there are states that do not entertain diplomatic relations with Israel, and statements in multilateral fora would need to be very specific in order to substantiate the awareness of a dispute. Now, I'm going to turn to whether turning to the ICJ would be a viable preventive option. Assuming that the matter is referred by the court, by Palestine or another state, the applicant state could file a request for the indication of provisional measures. These are urgent measures that are needed to protect the rights of the parties pending resolution of the case on the merits. The standard for the indication of provisional measures is lower than that applicable at the merit stage. One would only need to establish that the court has jurisdiction prima facie. There would be no need to prove that Israel is committing genocide, but it would suffice to establish that the acts complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. This is a lower threshold and one that can be said to have been reached in Gaza. Through an application for provisional measures, Israel could be ordered to suspend its military operations in Gaza, to refrain from committing any genocidal acts, but also public incitement to commit genocide, and to take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of genocide. So an application for the indication of provisional measures, if successful, could have an important preventive function. To conclude, I think that typically courts come into play after the facts or once the law has already been breached, and they're not necessarily best placed to respond to atrocities as they are unfolding, and are not fast in delivering decisions. The ICJ is no exception to this. A decision on the merits could take years, especially at this time that the court has a very busy docket. But provisional measures orders are an exception in this respect. They provide an avenue for the indication of interim measures that could play an important preventive functions. They're also treated by the court as a matter of urgency, so they take precedence over other requests. For example, in the case brought by the Gambia, the court decided on the request for provisional measures in over 2 months. In Ukraine versus Russia, it issued its order in under 3 weeks. There is, of course, no guarantee that a court's order indicating provisional measures will be complied with, even if it's binding. In fact, provisional measures orders are the court's decision with the highest non-compliance rate, but still having a binding decision by the World Court, even if it was reached on a prima facie standard, could be an important tool to sway other states, and especially Western states, in their support to Israel and to exert pressure on Israel. I leave it at that, and I look forward to the questions.
Thank you, Dr. Julia, for this insightful and very informing, I think, legal analysis of the viability of bringing the issue of genocide to the ICJ. I think the world now in a dire need for principled leaders more than judges and courts. Leaders can stop the genocide more than courts. With this, I will refer to our beloved hero, Professor Francesca Albanese, the Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967. We're glad that Professor Francesca will be able to join us in person. I believe she is traveling right now. She will address the issue of preventing genocide in Gaza, obligations of third states and the international community with a right-based approach. Without further ado, I'll give you the floor, Dr. Francesca.
Thank you so much. Also, thank you for the kind words. Not sure I I deserve that much, because the real heroes are those who are resisting this injustice. And I must say, first of all, I should salute all of you. I had prepared a video to send to you because, as you can see, I'm traveling from Paris to the Hague to try to bring Western leaders and Western institutions back to reason. And I've not been able to send the video. So yes, I'm here with you, which is great. I just managed to listen to Professor Spenzauti, and hi Julia, and sorry to have missed the others. Wanted to share just a few thoughts with you, hoping to contribute to what my friend Amar was saying, moving forward beyond the courts. I do believe the courts are necessary because the impunity that has been allowed to fester through and through for decades is part of the problem. And it's critical that individuals who are responsible for this madness pay through the justice mechanisms that do exist. Of course, there is the International Criminal Court, but there is not just that. Universal jurisdiction, it's a reality that involves also domestic courts that have competence to investigate and prosecute crimes against humanity, war crimes, and genocide. So it's very important, and I'm really glad to finally see some of these initiatives being discussed. I think that it's too late to discuss how to prevent genocide, because we can prevent these crimes to grow in gravity and intensity and scope. So yes, it's important to push for a concrete intervention beyond words of condemnation. It's absolutely necessary. So, but what can be done beyond the courts? Well, I think there is some opening, and again, it's very late. It's too little, too late. But I do see an opening with the move of the Secretary General taking some bolder steps and saying to the Security Council, I'm going to table what the points that you need to discuss. I'm going to table the question of Palestine as a priority, because I think the Secretary General realizes that this is the greatest catastrophe that the United Nations has faced since its inception. And it's a catastrophe from a political point of view, because the Security Council, but also the General Assembly, have proven once again unable to prevent atrocities, as it was in the case of Rwanda, as it was in the case of Kosovo, as it was in the case of Bosnia-Herzegovina, as it was in the case of Sudan, and. But there is something more serious here. This has not only happened under our watch, meaning while in real time. This has happened under our watch for real. It has been televised, announced, and followed up. So announced by Israeli political and military leaders, and then we have seen it unfolding, and we continue to see that unfolding. And on top of it, there is the responsibility of Western states. And again, through and through, because after 2 months, they keep on running to Israel to express solidarity, and again, full solidarity with the victims, full solidarity with Israeli victims, and full condemnation of the attacks on civilians that have been carried out. At the same time, with Israeli bombs having already killed 16,000 people, I find it absolutely insulting, this continued gathering of Western states around Israel without condemning. They say, yeah, Israel should respect international law. Israel was not respecting international law even before the 7th of October. Had it respected international law, we wouldn't be here. I'm 100% sure. So now it's the time to respect international law. What does it mean? Calling for a ceasefire now, cessation of hostility, is not even ceasefire, it's past the time for a ceasefire. Hostilities must end. Humanitarian aid must enter under UNRWA and other UN agencies' supervision. And it's not up to, frankly, it shouldn't be up to Israel to say what should be done to Gaza, because this sort of guardianship or this sort of authority that has been allowed to be exercised in Palestine for decades now must end. This can be a watershed moment to end this must be the watershed moment to end the occupation, which means that my advice, of course, this is something that needs to involve the Palestinians. I mean, there should be a powerful call from the Palestinians, but my recommendation is to have an international presence agreeable with the people who have been so far under Israeli occupation, so the Palestinians, and this protective presence should ensure sort of peace and stability, the withdrawal of the Israeli army, the release of all hostages and all Palestinians arbitrarily detained by Israel, but also it will be necessary to ensure the evacuation of all the people in Gaza who will not be able to stay. This shouldn't be a vehicle to force displacement, so no refugee camps in the Sinai. But at the same time, there are people who are sick, who are wounded, who have nowhere to go. And so they should be given the opportunity to choose where to go, because many of them are family around the world, and these people are also increasingly traumatized. So this is what I think should be in the immediate, I mean, between now and December, the roadmap ahead. Before thinking of anything else, 2-state solutions, 3-state solutions, I mean, political solutions should follow once it's clear that the path to peace can only be built with peace. And respect for international law and human rights is a necessary element, a fundamental building block of all this. Thank you.
Thank you, Dr. Francesca Albanese, for your presentation and for all the recommendations and requests that we all endorse. And I agree with you, maybe it's unfortunately it's too late to prevent, but we need to stop further atrocities and further death and killing, which is happening on like every minute. I think now it's we leave the floor for questions. We have the question box. I see several questions by participants. Most of the questions focus on the accountability mechanisms, like one of the participants asked about if somebody, a victim who has a dual citizenship, is interested in litigation, is there a legal aid venue? Is there someone who can provide legal assistance or advice on how to pursue a case in a foreign country, particularly in some European countries that has universal jurisdiction? A question also about the jurisdiction of Arab courts. Do Arab courts have jurisdiction concerning wars against humanity and genocide in the Gaza? A question also about the ICC, the viability of the ICC, and what we should expect from the case filed by a group of French lawyers. And the first hearing, according to the question, will be held in February 2024. Shall we expect something viable from this proceeding? Well, of course, this question is very relevant with the voices questioning the integrity of the public prosecutor of the court. A legal question concerning Article 122 of the Third Geneva Convention. Is there any interpretation to this article rather than that it forces states state parties to try those who are complicit in genocide? This is the question. So I have these questions. They are all, I think everybody is interested, and most of the people here are interested in the issue of accountability and how we can pursue it, whether at the ICC level or at universal jurisdiction at national courts. So also there's a question about the, I think Francesca alluded to that, about invoking Article 99 by the Secretary General, what we should expect from this invocation, and what are the implications of the tabling the situation in Gaza on the Security Council agenda. Question about the ICC and why it is enacting, what the inaction of the ICC or the perceived inaction of the ICC, and what we should expect from this court given the performance of its attorney or public prosecutor. There is a question to Professor Julie. Do you think that there is a need for preparatory work before we go to the ICJ? And is there a need to ask the permission of the Human Rights Council? Or is there, do you think referring to the Human Rights Council is also a viable option to prevent genocide or to stop genocide? Okay, I will, I think these questions, I will do the following. I will ask respected speakers to address the essence of these questions. And I will add to them later. So I will start maybe with Professor Pinzotti, Julia, and then I will move to Dr. Khafisha and to Dr. Quigley, since are like, and then I will, the next round of questions, I will distribute to other speakers. So please, in 2 minutes, Julia, if you please address these questions.
Sure, thank you. Can we ask the ICJ to identify certain acts as genocide? Yes, this is one of the things that the ICJ could do, bearing in mind that because of the seriousness of the allegations, the court would apply a heightened standard of proof for genocide allegation compared to other allegations. So, and this brings me to the other question: are there risks in approaching the ICJ? There is a risk that the ICJ might conclude that what is going on in Gaza does not constitute genocide, so to have a contrary ruling, although at least if one were to ask for provisional measures, given that there's a lower standard, I think that would be pretty unlikely at this stage. But on the merits, there would be that risk. Another factor to consider, in my view, would be whether a contentious case would have any negative impact on the pending proceedings concerning the legality of the occupation. Obviously, that is a request for an advisory opinion. But hearing is scheduled to take place in February next year, so pretty soon. Would a contentious case cause any delay in those proceedings, which are also very important, and maybe states intervening in those proceedings could take an opportunity to make submissions on genocide also before the court in that context? Is there any need for preparatory work before going to the ICJ? And is permission of the Human Rights Council needed? Permission is not needed. A state can bring proceedings to the ICJ directly, provided that he has no reservation that would prevent him from doing so. What I would advise is what I was saying before, to have some exchanges with the prospective respondent before the filing of the application, because the applicant state would need to show that the respondent, whether it's Israel or one of its allies, was aware of the existence of a dispute. So there needs to be some exchanges between the parties before the filing of the application. Otherwise, there is a risk that the case will be dismissed on that ground.
Thank you, Julia. I understand that Francesca needs to leave because she is on travel. So I will address questions concerning the invocation of Article 99 and also the viability of the ICC, given like the perceived bias or lack of action from the public prosecutor.
Look, I have to admit that the Secretary General took me by surprise with that move. So I'm currently studying the precedents of what has happened in the past in invoking, because it's quite unprecedented. There might have been one other case, but again, without the full picture of what the president is, I think that we should use, or the Secretary General may want to use this opportunity to give full meaning and charter in its intention to maintain peace and stability. Peace and stability also ensuring that basic rights of individuals and collectives are respected. And this is why I think that he needs to provide words, actions, directions to the Security Council. So I think that it's very important for the Secretary General to offer a roadmap out of the current and long-term goals. Long-term goals should be end of the occupation, and end of the colonization of what remains of historical Palestine. This is the unavoidable goal that needs to be pursued. But meanwhile, the short-term goal, as I said, should be a ceasefire, unfettered humanitarian aid, unfettered possibility for the people in Gaza to be evacuated as needed, and of course the release of hostages and other
Well, I think it seems that there's disconnection with Francesca. So I will move to Dr. Mu'taz Kafishe. Dr. Kafishe, if you could please address the two specific questions. One about the jurisdiction of Arab courts and what can Arab lawyers do in their respective jurisdictions. And second question, one of the participants asked about the view on whether Hamas action on October 7 it can be considered as a genocide. So could you please address these two questions?
Okay, first question regarding Arab jurisdictions. Of course, in law they have jurisdiction, but in reality we know that Arab countries and Arab courts are not likely to act on this. But I think maybe some Arab countries can work with Palestine, and maybe Palestine need to pressure some Arab countries to start a lawsuit against the case of genocide against Israel based at the ICJ, I think as quickly as possible, because Israel might withdraw from the Genocide Convention, or it may at least cast reservation on Article 9 of the Genocide Convention, and then that might make it difficult for the court to have, or even impossible for the court to have jurisdiction. So that is that's something that can be done maybe by some Arab countries or by other countries, because the Palestinian Authority itself or the Ministry of Foreign Affairs might have some political risks in filing this case, because Israel might put pressure on the Palestinian officials in this respect. So that other channels should be explored. Regarding what the October 7th, whether it can be an act of genocide or not, given the scale of that attack, I don't think that is a genocide. It's mainly an act that has been targeted against military bases. Probably there were some certain violations, but as has been uncovered by Haaretz newspaper, that most civilian casualties who were killed on October 7th were killed by the Israeli military based on the Hannibal protocol that Israel has, meaning that better killed than taken hostage. So I don't think it has anything to do with the issue of genocide in this respect. And this, of course, needs to be analyzed based on the context and based on the Palestinian rights of resistance, self-defense by the Palestinians. Of course, any attacks against civilians is condemned in legal terms, but it was clear on the October 7th that the attacks were targeted mainly and chiefly against Israeli bases. Finally, I just wanted to mention something regarding Article 99 of the UN Charter. I have two observations here. The letter of the Secretary General sent to the President of the Security Council, it's a bit biased because he used the term brutal attacks by Palestinians. And when it came to Israeli attacks or killing in Gaza, he said reportedly killed in Gaza. So the language was not really appropriate. Second, I think this act, or bringing the issue to the Security Council can be done or by any state, and the Secretary General here is acting like any other state party. But I don't think there will be. Of course, it's a political position by the Secretary General, but I don't think any tangible result can be achieved except if we revert to the issue of uniting for peace. And when the Security Council will fail, and I think it will fail, the issue can be transferred or referred to the General Assembly. And here, if we get the needed majority for taking an action based on Uniting for Peace resolution, then I think states, every individual state will have an obligation, erga omnes obligation, to do something against Israel. That could be diplomatic boycott, some other embargoes.
Thank you, Dr. Motaz. Professor Quigley, feel free to address any of the legal questions, but there's a question directed to you. Do we need to establish genocide on behalf of the committing state before recourse against complicity of other states?
Oh, the answer is yes. It must be established that genocide is being committed, but I think that is something that is rather easy to establish. There is, in fact, a case that has been filed in the United States against President Biden for complicity in genocide, making the argument that Article 1 of the Genocide Convention has an obligation to prevent genocide, and also that the United States is complicit in genocide. But on this question of reservations to the Genocide Convention, which has come up here in the discussion, Dr. Motaz mentioned the possibility that Israel could withdraw from the convention, which I think it could do. And he also mentioned the possibility that Israel could enter a reservation. I don't think it can do that as a legal matter. Under the Vienna Convention on the Law of Treaties, a reservation must be entered at the time that a state becomes a party to a treaty. the only thing that Israel could do would be to withdraw from the Genocide Convention entirely, and then it perhaps could re-adhere with a reservation. So that is a risk. For those states that are potentially plaintiffs, that is a state that is thinking about suing Israel, it has been mentioned, I think, by Dr. Julia that many states do have reservations to Article 9, and that prevents them from invoking the Genocide Convention against another state. However, a reservation can be withdrawn at any time. So a state that has a reservation could withdraw it and could immediately file, because the withdrawal of a reservation under the Vienna Convention on the Law of Treaties is effective at the time the withdrawal comes to the notice of another state. So good. Thank you, Dr. Julia. I see you're agreeing with that analysis, because there are some states that are in fact contemplating filing a suit that do have reservations. I've been in contact through third parties with a number of them. I have written a draft of an application that could be filed in the ICJ against Israel and against other states that do not have reservations to Article 9.
Thank you, Professor Quigley. I will address questions concerning the viability of the ICC and the under-resourcedness and the issue of credibility of the court, what we should expect from the court. Also, a question about whether characterizing the role of British Prime Minister and US President as inciting for genocide. Someone is questioning that, saying that incitement usually precedes the crime. Maybe there is other definition to what their complicity in the situation. So, Dr. Shuaibi, please try to address these questions.
Sure. I would actually like to talk about the questions relating to the ICC prosecutor. So, as many of you know, the situation in Palestine has been referred, there has been an ongoing investigation since 2015. And then Palestine referred the situation 2018 in order, to accelerate the work of the prosecutor. However, there has been a lot of question marks on the current prosecutor, Karim Khan. First, a lot of the work has been very slow. We haven't seen much work from the prosecutor on the issue of Palestine. However, since October 7th, the prosecutor has been more involved with the case of Palestine, but most of what he was saying can be called double standards. What he has been doing is within double standards. Because last week, the prosecutor visited Israel under the pretext that this is not an investigative visit, that he handled this in a different manner. However, this is unclear why did he visit Israel. He then extended the visit to Palestine. At the beginning, he only wanted to meet PA officials, and then he met some victims in the West Bank only, in Ramallah specifically only. So this raises a lot of questions on his bias. Why didn't he visit Gaza? Why didn't he visit victims all along the West Bank? Also, how can we characterize this visit? If it's not investigative, why did he issue a statement after the visit indicating that he will work on what he saw and he will be going forward on the basis of what he saw in Israel and the occupied Palestinian territories? So this opened a lot of questions on his credibility, and this is something that state parties to the Rome Statute of the ICC should be looking very carefully on. Regarding funding, actually last week, Belgium and Ireland both gave specific money to the court to investigate the situation of Israel and Palestine, 5 million from Belgium and I think 3 million from Ireland. So now there is money, and the ICC prosecutor cannot use the issue of funding as an excuse not to go forward. He did say that he will be hiring an investigator specifically to Palestine, Israel. So we'll see what will happen in the next few weeks. However, we should be very cautious when dealing with the current prosecutor because his bias is quite profound.
شكرا. Thank you, Dr. Hala. I believe there's a question to Professor Penny concerning the role of civil society, global civil society. And the question asks about how we can make like a bigger movement of change and to see like a more impact, particularly that some actors are not doing enough to advocate for the stop of genocide. The question also talks about that some civil society organizations joined lately. They did not act immediately from the beginning of the war, although it was evident that we were heading towards what we are seeing right now.
Thank you, and thank you for those questions. I would say initially that civil society isn't one unified body, and that there are reactionary elements within civil society, very specifically in Israel itself. Zionist organizations which are actually promoting the genocide. So civil society is a very mixed bag in some senses, but ultimately, I think it is our best way forward for actually challenging genocide in any country. And I think the question asks what more can be done. Well, I think it's really interesting. In Belgium 2 weeks ago, transport workers refused to process weapons that were designated for Israel, which would have been used in the bombardment of Gaza. So those Belgian workers were taking a really significant action and made a significant difference. Picketing of weapons manufacturers, demonstrations outside those factories, putting pressure on any kind of corporation which invests in weapons of destruction. I think the BDS movement is the most significant non-violent means forward. I think that we saw in South Africa the impact of the boycott, sanctions and divestment movement. And I think that we're seeing a growing interest in activating all forms of boycotts, particularly in the university sector where we work. We've been operating a boycott against Israeli universities for many years, and those universities are absolutely complicit in the current genocide. I think that in terms of what we can do, I mean, we need to be educating ourselves. We need to be reading about Palestine. We need to be reading about the history of the formation of Israel. We need to be speaking out. And in organized groups, we are much stronger. The demonstrations that we've witnessed across the world, in London, I mean, a march of 1 million people, over 1 million people at one time, in solidarity with the Palestinians is unheard of. It was an extraordinary event. And I think these are the kind of actions which civil society should be engaging in. We should be pushing motions in our trade unions to demand a ceasefire, to demand an end to occupation. And we have these mechanisms available to us. And certainly in London, I can see all of these civil society mechanisms growing because people are actually witnessing this genocide. And young people in particular, because of their access to social media, have taken on board the idea that Palestinians are being abused in the most appalling manner by the state of Israel, and they're not standing for it. And I think that there are various civil society mechanisms which can be used, which I think are absolutely much more effective than legal mechanisms. I think that I work on the genocide of the Rohingya in Myanmar, and it's true that the Gambia took Myanmar to the International Court of Justice, and symbolically the Rohingya found that very valuable, but the initial provisional measures which came out of the ICJ were simply really that the Myanmar state should abide by the Genocide Convention. which they weren't doing anyway. And so the idea that they need to be reminded by an international court as somehow being effective in challenging or acting in a punitive fashion against the Myanmar generals is, to my sense, somewhat absurd. So I think that civil society is our best bet. There are many things that can be done. I hope that's answered the question, at least to some extent.
Thank you, Professor Green. I think I need to apologize to some of our participants who also added new questions. I don't think the time of this event allows for further answers. But of course, we can, by email, we can respond to some of these questions. They are all relevant. I also want to mention this heartening message from one of our participants, Mr. Samer Jarusha, who's from Gaza, who talks about his family being, his house being bombarded by the Israelis on the 13th of November. And some of his family members were under the rubble, still alive, being able to make phone calls and asking for the ICRC to come and rescue them. They are still under the rubble. Unfortunately, after they passed away, no one was able to reach them. He questions the credibility and the effectiveness of IHL, of the ICRC, in helping or preventing what is happening in Gaza. Really, I can't find any positive note to end with, except maybe what Professor Green mentioned about how the world now, some sectors that never heard of are mobilizing to stop or to stand against the war in Gaza. I think we have two elements that we should continue to believe in. First, the resilience of the Palestinians, particularly in Gaza. And second, the humanity. I don't think that some parts of the humanity has failed us, but we should not entirely reject humanity. I think what we are seeing of demonstrations around the world show that we still have some humanity and that we can count on peoples around the world to continue to raise their voice on behalf of the Palestinians to stop the genocide. With this, I would like to thank all participants, all distinguished speakers, all those who raised questions and shared this event on their social media platforms. We'll continue to work together to try our best within our limited capability to stop the massacres and carnage that is happening in Gaza, and to try to provide some hope to the people who are facing death and immense risk on every minute basis. Thank you all, and we'll continue to stay in touch and hope this war will end soon. Thank you.